hone in on this particular area on data protection by design and default, because quite a few people have not been able to maybe understand what exactly goes into the requirements when it comes to data protection by design and default, because even within the regulations and within the acts, there are no predetermined mannerisms of how this is to take place and what is the expectation when it comes to data protection by design and default. So that is why it's quite important for us to understand what this would look like within our particular context, within our organizations, and what exactly we need to do to make sure that we are compliant when it comes to what is expected of us by the data protection laws in place. Allow me to just share my screen. Okay. Kindly confirm that my screen is visible. Okay, thank you. Okay. Okay, so when it comes to privacy by design, these are two key concepts when it comes to the protection of personal data within systems and also within processes, whether it be by individuals or by particular organizations. So privacy by design in itself basically requires that when we are coming up with a system, if we're employing the use of any new product, even if it's within a process, the goal when it comes to privacy by design is to ensure that from the onset, we are considering privacy. That privacy is not an afterthought, but it is something that we're considering from the get-go. So this is where in the initial designs of this particular system or process, we are already understanding what the expectation is from a privacy perspective, and we are already implementing. When it comes to privacy by default, on the other hand, this is where we have automatically put in place privacy mechanisms from the get-go. So it is not on the data subject. So the data subject in this particular context is any individual whose personal data is being processed. At this point, it is not on them to make sure that the privacy controls exist. It is where the controls are already implemented as a default. So what this means is privacy by design is a predecessor to privacy by default, because if we already consider what is the expectation from a privacy perspective when we're coming up with these systems, when we're coming up with these products, it means automatically at the point of use, at the point of introduction to the data subject, all these controls are already in place by default. So one predecesses the other. So one cannot exist without the other. Yeah, ultimately that is what that means. So these are just a few demonstrations of what it means to have privacy by design as well as default. So when it comes to our cookies, I'm sure a number of us, when we log into our website, we've been noticing a prompt when it comes to selecting which particular cookies we would want to apply to us. Some websites have utilized it, others don't. We have websites where it is quite blanket, where it's just a blanket agree. But if you just have a blanket agree to cookies, you have not essentially embedded privacy by design in the development of your website, because by design there should be a platform and a way for a data subject to choose which cookies they would like to apply to them. So now where the default element comes in when it comes to cookies is now at the point of now choice, automatically all the other cookies that I am to choose from are automatically off. It's not that when I am on the website, when I come to preferences, it is on and then it is for me to turn the same off. So by default, all of them are already off and it's for me to choose if I want marketing cookies to apply to me. But by design, it is the element of choice already embedded within the website. Also, when maybe you're logging into an application, if it's an application, or it's maybe you want to do a subscription to a particular service, whether it's through a web portal or an application, where on registration, I agree to the terms and conditions, and then there's also a requirement for me to accept whether I would want to receive any news or event information or any marketing information from this particular organization or this particular service that I am utilizing. So by default, by design within these applications or with this particular web portal, I am given the option to choose that whether or not I want to be ascribed to any marketing. But if the bottom part does not exist, this would mean that the design did not take into consideration my consent when it comes to marketing, or even if it was my agreement to the terms and conditions was lumped with marketing, then this would mean by design, my consideration of my consent was not embedded by design. Yeah, so this is just a demonstration of what privacy by design and what privacy by default would look like. So as was mentioned earlier by Anita, the Section 20 of the Uganda Data Protection and Privacy Act provides that data processors must ensure security of personal data in his or her possession by adopting appropriate, reasonable technical measures to prevent loss, damage, or destruction of personal data. So at this point, what is meant by the technical measures, that is where the data protection by design and default is encompassed within the act. That is where we find the requirement for us to actually undertake data protection by design and data protection by default. So also we can make reference to the GDPR, because as we understand, the GDPR is the foundational basis upon which the laws we have existent today, even in Africa as a whole, exist, because we borrowed quite a bit from the regulation, because it was quite detailed, and it was actually the first step towards regulating data protection from a global perspective. So this would be applicable to us in the instance that maybe our organization actually even processes data pertaining to EU citizens, because remember that the GDPR has extraterritorial implications where you are processing, even if you're not within the EU, if you're processing data pertaining to EU citizens. So the concept of data privacy by design, so the GDPR refers to it as privacy by design and default. We refer to it as data protection by design and default, but it means the same thing. The words are synonymous. So this is encompassed under Recital 78 and Article 25, where the appropriate technical and organizational measures are to be taken to ensure the requirements of the regulation are met. And then particularly when it comes to Article 25, it states that this is to take into account the state of the art, the cost implementation, and the nature, scope, context, and purpose for processing, as well as the risks when it comes to the likelihood and severity for rights and freedoms of natural persons. The controller must implement. So shall here implies that must implement appropriate technical and organizational measures. So this is where we employ the use of technology. You actually cost for these things. You're looking into the scope and the nature of processing that you're undertaking, and also you're looking at the risks related to the particular processing activities we're undertaking. Sorry. So data protection by design. So as we have established at the onset, privacy by design means within the system, the element of choice is considered from the get-go. And we are making sure that our designs, when it comes to our systems, when it comes to our services that we're offering, when it comes to a particular process, that the design we have in mind is privacy friendly from the get-go. We are considering the data subject from the get-go. We are operating within the shoes of the data subject. Yeah, so this is where we're ensuring, this is how we ensure that whatever we are trying to roll out in the sense of a system or a process is privacy friendly. So this means that the system provides choice to the data subject, whether he or she wants to share this information, and the default setting is the strictest one. So the strictest one being, if we have to make sure that it is off, and then the data subject actively decides that they want to put it on, that is where we demonstrate that we have put it in the strictest way. And then now, companies are actually encouraged to implement technical and organizational measures when it comes to the earliest stage of design. Yeah, so if we're rolling out a website, how are we considering the privacy designs? If we're employing the use of a software as a service, are we looking into this particular software to see if we have any default measures where we can automatically make sure that the data protection requirements are adhered to within the particular software? Or have we even engaging our developers to make sure that when we are developing these particular systems, we are considering data protection from the get-go? Yeah, so this is how we make sure that from the earliest stages of the design, we are incorporating things like that. So for example, I will give an example of, for example, an application such as Zoho. They have embedded within their software an automatic, when you go to the settings, you can automatically just allow for GDPR requirements to be embedded within the system. And when you switch that on, automatically the system processes data in accordance with what is required with the GDPR. So that is an example of how that has been demonstrated at a software level. So basically, when it comes to privacy by design, it has to be from the upfront and from the beginning, from the beginning of the architecture, and even when we are beginning to document any processes or anything around interaction with data subjects, we are making sure at the onset we are considering privacy. So what are the principles of data protection by design? So you have to be proactive and not reactive. So this brings into this context the element of making sure we have done it from the onset. We have done it proactively. We haven't waited for an incident to occur, for a risk to materialize, and then now we are working backwards. We have not waited for a breach to occur, or maybe even for a data subject to maybe bring a complaint to the supervisory authority for us to start embedding. We are doing it proactively. Yeah, and then now privacy is the default setting, so it applies by default. It is already there. It is already embedded, because you remember we mentioned that privacy by design is a predecessor for privacy by default. So this means that the design of the programs, whether if it's communication technology or any system, from the beginning, it should identify that these particular requirements must exist. Yeah, so where possible, we're looking at identifiability, we're looking at observability, linkability, to make sure that at a bare minimum, we are minimizing any processing of personal data where we are required to. And then now we should also ensure that privacy is embedded into the design. Yeah, so whatever process it is, whatever technology, whatever architecture we are using, even if we're using any new creative means, we embed design privacy within the design itself. And then it should be there should be full functionality. Yeah, so here we are accommodating any legitimate interests, and we're ensuring a win-win. It's not an instance where we stand to benefit and the data subject stands to lose. Yeah. So here we are focusing on privacy, and we're looking out for the best possible outcome for both individuals involved. That is the controller or the processor, as well as the data subject. And then also there's the requirement to ensure that there's security end to end. So here we are making sure that there are no gaps within even the system, even when it comes to how we have set it up, that there is no chances, because when it comes to the goal of privacy is to prevent any unauthorized disclosure. So basically, when we are trying to make sure that we are protecting data end to end, we're making sure that there is no point at which there is a loophole for data to be disclosed in an unauthorized manner. So here we are putting the strongest securities, we're employing the best mechanisms to protect data within the design itself. Then also there's the principle on visibility and transparency. So here we are seeking to ensure that everyone is aware, all the stakeholders are aware of all the parameters of processing within this new technology, within this new process. It's visible, it's transparent, and it's very clear cut. So an example of where this would not apply, for example, at what I had mentioned earlier, where you log into a website and then you just see cookies, agree, it's just agree. You don't even have an option to decline. If it's only agree, I have to agree for me to be able to utilize the website, then that would mean you're not exercising the principle of visibility and transparency, because I don't even know what I'm agreeing to from the onset. And I might just agree because I need to use the website, but that would mean you have failed in this sphere. So full transparency, full visibility, full understanding. Yeah. And then also we are another principle is to respect user privacy. So here we are making sure that within the design, the architects and the operators, whoever is developing whatever we have in mind, whether it be a process or a system, we are at most we are considering the rights of data subjects and their right to privacy. Yeah. So we are making sure that we are empowering even the user, is also going to be the data subject, and we're making sure that it's so friendly to the point that they can understand it. It's not unnecessarily complicated. It's in an easy, user-friendly manner. Yeah. So to work to ensure that we are respecting this, we are making it user-friendly, and the usability should not be too complicated even within the design. Then now, when it comes to now data privacy by design, we have to make sure that we're able to demonstrate the principles clearly through our design. So we are showing how we are safeguarding data, and how we are safeguarding the rights and freedoms of data subjects. So when it comes to, from an implementation standpoint, what are the two elements that this brings out? So first, even Section 20, the way it is worded, there's no specific, it does not elaborate. It doesn't say this is what technical measures mean, this is what organizational measures mean. Yeah. So it is on now, based on that, we have just been required to actually just implement these technical measures, and they have to be appropriate. So what does this mean? This would mean now it is on the data controller and the processor to actually come back and understand and document and basically also communicate what are the indicators for us to demonstrate compliance with this requirement. Yeah. What are the key performance indicators that we need? What are the metrics that we will need to measure ourselves against what is required, so that we know we are adhering to this requirement for ensuring that we have technical measures within our processes and within our processing of personal data. So it brings the spotlight back to us. As much as it is a requirement, we have to be the ones to demonstrate this. Yeah, and we have to be proactive within this as well. Then now we are going to delve into data protection by default. So as I mentioned earlier, default just means that basically we are making sure that the personal data we are processing is not it's not available to an indefinite amount of people. Basically, we are making sure that we are, by default, we are minimizing the data that we are collecting, because this privacy by default is closely tied to the principle of data minimization and purpose limitation, because it basically, we are limiting, we are only collecting what is necessary, we are only processing what is necessary, we only have a specific purpose, we are not changing purposes, because this is how we demonstrate that we have privacy by default. Yeah. So even when, that's why if I link it back to the image that I had shown earlier, how this is shown is where only the necessary cookies are being automatically processed within the website, and all these others are by default turned off. If they were turned on, it means we are not minimizing what is actually being processed from the onset. So this is, and even when I'm giving my consent is just to be able to access the website. So if you lump my consent, this would mean that you have not limited the purpose for which I have even consented to you processing my data. So that is how, at the bedrock of the data privacy by default, we are focused on data minimization and purpose limitation. So this would mean that it should also be we should have privacy-friendly settings when it comes to our services, our products, or even our systems, and that we are utilizing, that we are fully cognizant of the requirement of data minimization and purpose limitation. So when we're talking about data minimization, this is both quantitative and qualitative. So basically, us as the controllers and the processors, we have to consider what the volume of data is that we're processing, what the type of data is that we're processing, what category it falls under, and what's the level of detail of personal data that we are actually processing. So when we decide to go against the grain and retain this data for longer than is expected, it must be justifiable. And if it's not justifiable, we have to make sure that we have the identification techniques in place. This includes anonymization and pseudonymization. So anonymization is where basically both these techniques are where we are making the personal data that we are retaining no longer identifiable back to the data subject in question. So there are different techniques. So within anonymization, there are different techniques. We have, for example, masking. So this is where I'm sure you have maybe interacted with this, where you would see a number, you see X, and then it's only the last 3 digits. That is a form of anonymization because there is no way I can be able to link that number to anybody because it has been masked. And that is a form of anonymization. We also have adding noise, where you add noise to a particular, if it's an image, I cannot be able to see this particular image, or even generalizing the data. Yeah, where if we were processing data, maybe for example, we were doing some research and we want to retain this data for a long period of time, and we interviewed, let's say, a group of 50 people, instead of retaining the names of all 50 interviewees, if you want to retain this data for, let's say, even 50 years, we just generalize that data and say 30 males and 20 females were interviewed. That way, no one can be able to know who these particular people were. And then pseudonymization, the techniques under this could include encryption, where you actually encrypt the data, and then now the only people who can be able to access this data are people who have the keys. Yeah. So this, if you would want to also demonstrate privacy by default, you have to have these mechanisms in place because of the element of long-term retention, or retention for longer than is necessary. And then even outside of this, you should also have like retention schedules within your data retention policy, or even your privacy policy, where you're demonstrating that this is how long we keep these particular types of personal data, where you are also held accountable. You only have this time period, and if you retain it, and once that period clocks, you are automatically required to come back and actually dispose of this data, or employ the mechanisms for the identifications that we've just identified. So personal data at the core of privacy by default, personal data should not be made accessible to in just an indefinite number of people without the individual's intervention. So also they should be aware that this information is being made available to so-and-so. And then data controllers as well as processors must by default limit accessibility before publishing or making available any personal data within the possession of the particular controller and the processor as well. So what are some controls that we can have in place to ensure that we have privacy by design in default? So there are a number of ways we can demonstrate this, of course, as clearly indicated earlier. But ISO 27701, which is the privacy standard, which is also referred to as PIMS, which is a privacy information management system. This standard basically speaks to how to implement a privacy information management system, and also how to make sure that it is effective and it is running efficiently. So within ISO 27701, it has identified what controls have to be in place, both from a controller perspective and a processor perspective, when it comes to privacy by design and privacy by default. So some of the controls identified include limit the collection of personal data to a minimum, making sure that we are only collecting what is relevant, proportional, and necessary. So collection is identified separately from processing. So we are also required to limit the processing and make sure it is adequate, relevant, and necessary as well. So when it comes to limiting the processing, what we're looking into, because you can collect data and all you are doing was collecting, but then when it comes to processing, even backing up data is processing, transferring data is processing. So basically, where we do not need to transfer, we do not transfer. We only transfer where it's relevant and necessary. That is what the difference between the two controls. Then we also, to ensure and document that personal data is accurate, we make sure that it is up to date and it's necessary for the purpose throughout the life cycle of the personal data. We are also to define and document data minimization objectives and what mechanisms for the identification we would employ when it comes to meeting our de-identification objectives. Then we should also delete personal data or render the data that is to make the data no longer re-identifiable to the data subject if we would like to keep it longer. But if the time frame for retention of this data and we don't have these de-identification techniques, then the requirement here is to actually dispose of this data. So what would this mean? Is that we should have a data retention, archiving, as well as destruction policy, so that it could guide how we go about deletion of personal data whose purpose has expired. Then you do not retain data for longer than is necessary for the purpose. And then we should also document any policies, procedures, mechanisms when it comes to disposal, as I indicated earlier. And then also, where there's any personal data that is subject to transmission, we should make sure that there are appropriate controls when it comes to transmission of this data, so that it only reaches the people who it is intended to reach. So these are just some of the controls that we can have in place to ensure and demonstrate that we are actually employing the technical measures requirement, that is data protection by design and default as well. Okay, so that has brought me to the end of my presentation. So I think I would hand it over back to Anita, and then maybe we could kick off the Q&A. Thank you.
Okay, thank you very much, Cindy, for that very educative presentation on data protection by default and data protection by design. We are just going to dive into the questions. I have a couple of questions in the chat and Q&A. I'm going to wait for you as you respond to the question. The first question was, what is the best way to incorporate informed consent on a physical attendance? Yes, over to you.
Okay, so the question is, what is the best way to incorporate consent?
Yes, on a physical attendance.
On physical attendance?
Yes.
Okay, so demonstration of consent. So there are multiple ways you can demonstrate consent. So signature is a good way to demonstrate consent, or having a tick box. So where maybe if it's for example, if it's an event you're organizing and the registration is online, you can indicate within the registration platform a tick box where the data subject understands that this data is going to be processed particularly only for the purposes of attendance of this particular event or this particular webinar. And then if you would also want to use this platform to also market to them, you have an additional tick box to them accepting you sharing any news and information further from the webinar as well. So you can demonstrate this through a tick box. You can demonstrate it through a signature where it's in a physical form, or you could also put a tick box within a physical form as well. But remember, as it must be expressed, it must be demonstratable. So that's why verbal consent could not be the best place to rely on, because how will you evidence consent? So I hope I've answered the question.
Yes, thank you very much. That has been perfectly answered. I'll move on to the next question. As someone would like you to shed light on the difference between a data controller and a data processor. Over to you.
Okay, thank you. So a data controller is an individual or an organization that basically determines the purpose of processing personal data and determines the mechanism of processing of the data end to end. So they determine the purpose and then they also determine the means of processing the personal data. So they determine anything that happens to the personal data from collection up until disposal. They're the ones who determine what can be done with the data and what cannot be done with the data, and even the reason for actual collection and processing of the data, which is the purpose. Now, when it comes to a data processor, these are individuals or organizations that process data on behalf of a controller. So they do not do it on their own volition, they do it on behalf. So basically this emanates from a contractual obligation to provide a very specific output. So these are mostly our service providers, yeah? So for example, if you are an organization and the HR function undertakes background checks, maybe you want to engage a third party to do the background checks for you. So that third party can only use that data for the purpose of verifying that the individual that is being considered for a position is who they say they are. This third-party service provider cannot turn around and start maybe storing the data for longer than is necessary, start marketing to this particular individual, or even sell that data, because they have a very specific output and they can only work according to what is provided for within that contract and according to the instructions of the controller that is engaging them.
Okay, thank you very much. We shall move on to the next question. Someone says, how and where does one report suspected or actual issues of data breach? Cindy, I'm going to read this with the next question because they are almost the same, so that you're able to answer them at once. His question is, in view of globalization, where a breach of data protection can be committed by an entity in a different jurisdiction, where can this be reported and what legal system would apply? So this, and then the first question, which was, how and where does one report suspected or actual issues of data breach? We can just answer that together. Over to you.
Okay, so within the Ugandan context, you are required to report this to the Data Protection Office, which is embedded within NITA Uganda, and that is the requirement. It's actually embedded within the law when it comes to data breaches, the fact that you are supposed to report this to the supervisory authority, which is the Data Protection Office. And then from a global perspective, when it comes to reporting of data breaches, so it also depends on the context of the organization, yes? Because the understanding is, if you are a multinational organization, you might have different regulators that you would have to report to. So ideally, when it comes to the global context, where the company or the organization or the individual is domiciled, the supervisory authority there would take precedence over other supervisory authorities. So now, once you notify this particular authority, then any additional notification that you're required to do can be maybe communicated based on maybe if the headquarters of the organization are, for example, in the United Kingdom, for example, yeah. So there you might have to report the same to the ICO, which is the supervisory authority there. Or if it's in France, you would have to report the same to CNIL, which is the supervisory authority there. But the reporting requirement from a global perspective, the first point of contact should be where the organization or the individual is domiciled when it comes to notification of data breach to the supervisory authority.
Okay, thank you very much. That has been answered. The next question we have here is, how long are you supposed to retain someone's personal data? Over to you.
Okay, so this is actually quite an interesting area because various institutions have various interpretations of how long they can keep their data. So where a time frame is provided for by statute, where it is embedded in the law, then of course you would have to abide by the law. So for example, for financial institutions, you would find that the regulators, such as, for example, the National Bank of Uganda or the Central Bank of Kenya, in the regulator is the one that determines how long data should be retained when it comes to customers. So sometimes it is already embedded within the law that you have a minimum of 10 years to retain this data. Sometimes it is 7 years, depending on the particular context of the organization. However, you are required to have reasonable time. So where it is not expressly indicated within the law, you're required to have reasonable timeframes for retaining that data. Because, for example, let's give an example where we are a company that has sales and we do activations, yeah, to bring in more customers for our products. And where we go, maybe we have like, we interact with so many people and we collect their names, their numbers, so that we can follow up with them and hopefully convert them to potential, to our actual customers, move them from potential to actual. And then maybe we have a list of 100 people, and then only 3 people in that list actually become our customers. You cannot justify retaining the information of the 97 for 5 years or even 3 years, because how would you explain why you keep all that data? Yeah, especially considering if your turnaround time for customers is, for example, you're able to assess this within a year, then it would make more sense for you to retain this data for a short period of time and then redo the actual activations again. So you give yourself maybe a period of 1 year, you give yourself a period of 8 months, long enough for you to continue these conversations. And if the conversations are not fruitful, you'd either delete that data or you mask this data. So if you want to keep data for an indefinite period, you have to, of course, employ techniques such as anonymization, yeah, where it can't be linked back to the data subject. If you would like to do that, then that is the only approach you would have. But basically, we have to understand that when we're coming up with a retention period outside what is provided for within the law, then you have to be able to justify and demonstrate why you are choosing this particular period in such a manner that you are not making it detrimental to the data subject. Yeah, so those are some of the considerations you have to have when you're coming up with a retention period.
Okay, thank you very much, Cindy. There is a very, very interesting question here. Someone says that the personal data relates only to living data subjects, or they outlive data subjects who are deceased. Is consent needed from the next of kin?
Okay, that's a very interesting question, actually. So maybe I would give an example. So within East Africa, what I have noted is the only act which has gone a step further to protect the data of deceased data subjects is the Rwandan law. So this is where they have provided a right within the rights of data subjects. So there's a right to the next of kin. So it means that when someone is deceased, the next of kin can operate as if anything is to happen pertaining to this particular person's data, the next of kin can actually step in as an interested party and actually follow up any issues or make any complaints on behalf of the deceased data subject. So this is the only country where I've seen it has been put expressly, but even though within other laws it is not expressly provided, it doesn't change the fact that because even the way the law is written, it does not say living, it just says identifiable. So even if you are deceased, and I will be able to identify where you live, where you work, your phone number, it means you're still a data subject. Yeah, it does not set a boundary around living or deceased. So the implied implication of this is that even deceased data subjects' rights can be contravened, and if you do not process the data according to the law, then they are next of kin, even just by operation of law, because we have cohesion within the law. So even within the context of succession, a person can actually bring an action against you on behalf of their deceased kin, still even within operation of just the general law of succession as well. So this is where you see an interplay within the law of succession and data privacy law, but within Rwanda, it's expressly included within the Act.
Okay, thank you very much for that. Someone was asking, as an organization, what am I supposed to do in collecting data of individuals, or what are the proper measures of collecting data from a person? Maybe before you answer this, Cindy, I would like to let the person who asked this question to know that they can reach out to the office, because I feel the question is really broad. They can just reach out to the office for a training on data protection and privacy, because we do need training. Yes. Okay, so I'll read for you the next question. What is the difference between anonymization and pseudonymization? Over to you.
Okay, so the difference between pseudonymization and anonymization, between the two techniques, one of the most notable differences is one is permanent and irreversible, and the other is reversible. Yeah, so anonymization in this case is the one which is irreversible. And when it comes to pseudonymization, the same is reversible. What do I mean by this? So when you mask data, if you have a sheet of maybe 100 numbers, and all these numbers, all I can see is the last 3 digits. No matter what I do, no matter how I try, there is no way I will be able to decipher all the other digits for these other numbers. I can't reverse it, yeah? But when it comes to encryption, for example, if I have a key, if I gain access to the key, I can easily decrypt and then re-identify the data subject. Yeah. Also, there's another technique within encryption known as tokenization. So tokenization is where maybe I add a pseudo to your name. So for example, maybe my name is Cindy. I rearrange the letters. Yeah, within a list of maybe contacts, I rearrange the letters. So on the first glance, I wouldn't be able to know this is Cindy Koyer. But then if I take the time to change around the letters here and there, I can be able to come out with the name Cindy Koyer. So tokenization is a method of encryption. So that's how you see also it is actually reversible. So that's the notable difference between the two techniques.
Okay, thank you very, very much. I'm going to read the next question. Someone would like you to elaborate on the options, the different options available for data archiving and destruction.
Okay. So the different options available for archiving. So what some of the ones we've already talked about for archiving is employing the de-identification techniques, so that you are even in your archiving, you're practicing privacy by design. And then other forms of destruction. So for example, for computers, yeah, where you want to wipe out. So there's a mechanism called as degaussing, where you use a magnet and then it wipes out any data that is within the computer. Yeah, so this is for hardware. Of course, now you have other forms of data. So if data is in hard copy, it's forms, it's actual documents. So we have, of course, the shredding. We have using safe houses to archive this data. Yeah, so where you have a contract and then they are locked within a safe house with CCTV and even biometric access. Yeah, so these are just some of the ways you can. That is archiving, and then when it comes to destruction, there is the degaussing, the shredding element of actually destroying this data.
Okay, thank you very much. I am going to move on to the next question. We are really burning you with questions, but there are
it's okay.
Still coming. Yeah. So the next question is, what happens if the data controller illegally uses my data, for example, selling to a third party without my consent?
Okay. So in instances where you have not consented to this data being shared with a third party, you are not informed in any way, even through a privacy policy or even communication through whichever communication channel to particularly with the institution you provide this data with, penalties would accrue. Yeah, so they are within the law. There are ascribed penalties for institutions or individuals that contravene this requirement for consent, and also ensuring. So there is the right to be informed as a data subject, and also there's a right to consent. So in that instance, two of the requirements of the law have been breached. So in that instance, that would mean the penalties within the law would apply. So you notify the data protection office, and then once this complaint is made, then they will be required to show cause, and if they're not able to, then they will be automatically penalized. But then outside of this, there are other, you're not precluded from pursuing remedies within the law. So where you can actually go to the court of law and apply and make a prayer for damages from the court. Yeah. So there's the element of the remedy from the court and also from the penalties within the law.
Okay, thank you very much. There is another question about how to carry out a DPIA within an organization. We did a whole webinar about DPIA, so I would request this person to reach out to us via email. Just send an email to info@pdpo.go.ug, and we'll be able to share the details of that webinar. However, Cindy, I don't know if you would like to say anything about the DPIA.
I could mention something, maybe just a high-level explanation. So a DPIA, basically, a DPIA is required to be conducted. This is a data protection impact assessment. You're required to conduct this where a processing activity you are undertaking in is likely to pose a high risk to the rights and freedoms of the data subject. Yeah. So as opposed to a risk assessment, which looks inward, a data protection impact assessment looks at the data subject. We are focusing on what impact this would have to the particular individual. So when we are conducting this, we are trying to understand how is this processing activity going to impact the data subject? What is the information flow? How are we adhering to the rights of the data subject? How are we adhering to the principles of data protection? Who are we granting access to this? Is it absolutely necessary for us to undertake this processing? Is this, do we have a lawful basis to undertake this processing? And also, from the onset, you have to identify whether you need to conduct a DPIA, because there are specific activities that have been highlighted as high-risk processing. So for example, it's not just all activities. There is a set criteria for which activities constitute high risk. So this could be any systematic processing of systematic monitoring of a publicly accessible area. This is CCTV. If you're employing the use of new technology to process data, if you are changing the purpose for which you're processing data, or even collecting additional data within this process. If the data subject will not have a way to enforce their rights within this process, then you would require a DPIA. If there's any element of automated decision making within the processing, so automated decision making is where we have it's done automatically. So it's done maybe even on the sorry, let me just put my computer to charge. So yes, it's in a way that it's done automatically through maybe a computer or a set algorithm, and the decision is not made through a human intervention. It is just done automatically. And then also, if you're maybe cross-referencing different sets of data, then this would also, so if you're taking data from different systems and then putting it in one particular system, this means you're cross-referencing, you're pulling data from different data sets. So that would also form a high-risk processing activity. So once you establish whether there is a need, if a need is identified, then now that's when you follow the course of trying to identify the risks and understanding the information and how it affects the rights of the data subject. Yeah.
Okay, thank you very much. most of the questions we are remaining with are about the retention period, which you have really answered. But I'm going to pick out a question. Someone asked if someone has refused to give me their personal data, yet I need it to render a service. Should I go on and render a service to them?
Okay, that's a good question. So now, within the law, we have this thing called lawful basis of processing data. So within the lawful basis for processing this is basically what you're relying on as the reason why you're processing this data. So we have consent. Consent is number one because it boils down to the inclusion and the engagement of the data subject, giving them agency over their data. That is consent. But then it's not in all instances where a data subject can also choose not to consent, because in such an instance, for example, if you want to register an account with us and we are a bank, yeah, there's specific information we are required to obtain from you, even from a regulatory perspective, before we can open that account. So you can't decide and say, I'll give you this information, but I won't give you this information. If you do that, then we will not be able to provide you this service. So where the data subject says, okay, if I don't consent, what else can you rely on? Yeah. So there are additional lawful bases that have been included to processing data. And now within the bank's context, what one of these lawful bases is referred to as legitimate interest. So legitimate interest, this is where you're required to process this data because it is in the best interest of the bank to do so. And then an additional lawful basis is legal obligation. So legal obligation is where you are actually required by the law to process this data. Yeah. So for example, even KRA, this is government institutions, even regulated institutions. So for example, if you're an insurance company and you want to make an application for insurance, the regulator for insurance has put a bare minimum of the information that's required. So that's a legal obligation. Then another lawful basis is contractual obligation. So you are processing this data in furtherance of a contract that is existing between you and the data subject. So because of that, you would have to process this data. So what's an example of this? For example, an employee contract. Yeah, if I have a contract with an employee and I want to provide them with medical, which is a requirement under the contract as an obligation for me as the employer, then I would require them to provide me some information, additional information, probably health information that I can provide to my third party insurance provider so that I can facilitate. So I'm only doing that to fulfill my obligation as an employer within the contract that we have existing. Then we also have public interest. So this is where you're processing data as a matter of public interest. There then the data actually has to be provided. So public interest, this is instances of, for example, where there's a census being undertaken, or when it comes to issues of anti-money laundering, where you're supposed to declare any politically exposed person that you have access to, or anybody who has been discovered to be laundering money. This information is disclosed and shared. So it's those instances. And then we also have vital interest. So vital interest as a lawful basis is where you're processing this data because it is in the vital interest of the data subject to do so. So now, as opposed to legitimate interest, this is where now we're looking at the data subject. We're doing this because it's beneficial to them. So an example of this would be where banks require us to do biometric. We give our biometrics because this is just an additional step to protect our account information and even our transactions with the bank. So it's done in the best interest of the data subject. Yeah. So those are the additional. So outside of consent, you can explain to them that it's a legal obligation, so they have to provide it to you. Otherwise, you will not be able to provide that service to them. And if they refuse, then unfortunately, it would be difficult to proceed.
Okay, thank you very much, Cindy, for your time and for answering all these questions. Maybe if you can give your parting shots.
Okay, thank you so much, Anita. Thank you so much for all the participants. Thank you so much for very insightful questions. It's been quite an engaging session, and we've delved into some interesting new topics. For example, that element of whether data subject needs to be alive or they can be deceased, if that would apply. That it has really led to some fruitful discussions. I truly hope that I have provided enough information to each and every one of you when it comes to the sphere of data protection, specifically when it comes to data privacy by design and default, and that you will be able to implement this within each and every one of your organizations, or maybe start off this conversation to ensure that we are fully compliant with what is expected under the law. Thank you so much once more, and I can hand it back over to you, Anita. Thank you.
Okay, thank you very much, Cindy. It has really been a great pleasure having you today. The session has been very educative, and I really hope that members, you've been able to pick something that you're going to use in your organizations for the good of data protection and privacy. Thank you so much, members, for attending this session. We always have these sessions every month, every last Thursday of the month. Please make sure you attend. They are basically to educate you as DPOs to know what you need to implement in your companies and organizations. If you had any questions that go directly to the office, please call any of those numbers that are posted in the chat, or send us an email at info@pdpo.go.ug, and then we'll be able to answer you. I have shared a link in the chat. Please click on that link and give us your feedback. I will not close this webinar immediately. I'm going to wait for about 2 minutes to give each of us time to be able to click on the link and put in their feedback. Thank you so much. Thank you, Cindy. We are very excited we had you today, and thank you the rest of the members. Have a wonderful day.
Thank you, Anita. Thank you, everybody.
Thank you.